Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to describe the top 5 issues that married couples with a $5 million estate deal with as part of their estate planning. So it's been a couple of months since I've made a video, and I want to thank all of those who have inquired about my well-being, but any rumors of my demise are greatly exaggerated. My wife and I spent a month in Colorado, and all 5 of our young adult kids spent time with us there as well. We had a great time. So while each couple and each family is different with different estate planning needs and objectives, I'm going to explain the top 5 issues that married couples with an estate of $5 million typically address when getting their estate legal affairs in order. I've personally dealt with hundreds, if not thousands, of couples in this $5 million estate value range. So I know what they worry about, and I know what discussion points get them really engaged in their estate planning. So the first issue that couples with a $5 million estate value often address is avoiding probate. Those probate costs and delays can add up, particularly if you live in a state where the attorney legal fees, the executor fees, and the court expenses are based on a percentage of the value of the estate. If you have a $5 million estate and the total probate expenses are, let's say, 6% of the estate, that's a $300,000 outlay. In addition to the delays inherent in probate, particularly with a $5 million estate that is likely to own many different types of assets and accounts. Avoiding probate generally involves establishing your revocable living trust, transferring those assets that would otherwise have to go through probate if they were in your name when you die to your trust, and also structuring the ownership and beneficiary designations correctly on assets where it's appropriate to do so, like IRAs and life insurance you own. The second issue that the $5 million couple addresses is taxes. And while the federal estate tax exclusion of $12.9 million exempts the estates of the $5 million couple from federal estate tax, there are income tax and capital gains tax considerations that must be considered when planning to keep a $5 million estate intact for the family. All couples like the concept of that step up in basis when the first spouse dies, but smart planning is required so that all assets of the couple get another step up in basis when the surviving spouse dies. And if the $5 million couple has assets that have significantly appreciated in value since their acquisition, this step up can also save hundreds of thousands of dollars upon a disposition of the assets after both spouses pass away. And while, generally speaking, an inheritance is not subject to income tax to the person that receives the inheritance, there are income tax consequences to inheriting a traditional IRA or 401k, and excessive income tax can be required to the extent you leave behind assets in a trust for a beneficiary, and the income that the trust assets produce is accumulated in the trust. So even though there may not be federal estate tax concerns for the $5 million couple, other taxes can drain resources from the estate. The third issue that the $5 million couple often addresses is making their children's inheritance divorce-proof. If a $5 million estate ultimately gets divided among 2, 3, or 4 children, those children will be receiving a 7-figure inheritance. It would be a shame for a child to inherit 7 figures and then subsequently get divorced from their spouse and have to split any remaining inheritance with your ex-son-in-law or ex-daughter-in-law. By leaving your child's inheritance to a trust for them, you can add a layer of protection so that those assets don't get mixed or commingled with other assets your child has with their spouse. The fourth issue that the $5 million couple addresses is how they leave their portion of the estate to their surviving spouse. Bluntly speaking, this is the old conversation that goes something like, what if I die and my spouse remarries and wants to leave our estate to their next spouse, totally excluding our children? So married couples have an important decision to make regarding how the first spouse to die will leave their estate to the surviving spouse. Do they want to leave their portion of the estate outright to their spouse, which is kind of simple? Or do they want to leave it in trust for their spouse to give the children more protection and increase the likelihood that children will receive assets upon the death of the surviving spouse? And the fifth issue that the $5 million married couple must deal with is all of those appointments that must be made in the estate planning process, from powers of attorney for financial decisions, and another for healthcare matters, to executor, to trustee. Most married people appoint their spouse as the first person in line to handle these things. But couples often struggle as to who should be appointed to be in charge of different things if the spouse has died or is not able to do things. Should the backup to the spouse be the oldest child? Should it be multiple adult children together? Should it be a third party? And if so, should that third party be an individual or a corporate fiduciary? Many couples struggle with the decision of whether to select the adult child with the best skill set to handle these things versus a concern about hurting the feelings of a child that doesn't get appointed to one or more of these positions. So since every couple is unique, there's likely to be many other issues that must be addressed as part of the estate planning process. But this $5 million estate is sort of the sweet spot for our national estate planning law firm called America's Estate Planning Lawyers. I hope that this video has provided you with some value, perhaps even confidence that you can go do this for yourself and your family. Have a great day.